In Sabah, native customs can be found in administrative codes, legislation, judicial decisions, and also unrecorded oral traditions. In administrative codes, it is a written collection of native law for administration purposes. It is drawn up by administrative officers, and the most well-known code is Wooley's Code, which covers inheritance, marriage and divorce, and also compensation matters. Under the legislation, the main statutes relating to native customs in Sabah are Land Ordinance 1930, Native Rice Cultivation Ordinance, and also Native Estates Ordinance. When we refer to the judicial decision, the collection of native law cases was compiled by Tan Sri Lee Hoon Ho, which was the former Chief Justice of High Court of Borneo. Other existing law reports also compiled native customs, which are North Borneo law reports, and also Malayan Law Journal. Reported cases covers mainly on matters of family law, land, and property. Most cases are on betrothal, marriage, succession, and relationship between natives and government. One example can be found in the case of Gulis and Mallan, where a failure to invite wife's relatives to a wedding was a breach of custom, and thus the defendant has to pay compensation. Next, moving on to native customary law in Sarawak, where the customs are found in administrative codes, statutes, and also judicial decisions. Under administrative codes, Dayaks administered system of adats to regulate matters like community, living, religion, marriage, and inheritance. During Brooks' period, it was codified under Native Customary Laws Ordinance 1955. And among the native law texts regarded as administrative codes are the Si Dayak Code of Fines, the Orang Ulu Customary Codes of Fines. The two compilation of Adat by A.J.N. Richards were published as administrative codes, namely Dayak Iban Adat Law and Dayak Bidayuh Adat Law, and it was later replaced by Adat Iban and Adat Bidayuh. Adat of various different groups in Sarawak had been codified under codes according to each community and was modelled after the Adat Iban 1993. Each code has 8 chapters dealing with breach of adat, which requires payment of fine, tunggu, longhouse and rules of behaviour for members and visitors, customs relating to farming, marriage and related offences, property, death and burials, child adoption, and also other matters including procedure for beginning an action in native court. The effect of codification of customs is certainty to the applicable custom, where all customs gazetted through codes becomes legal documents subjected to doctrine of stare decisis. Customs which are provided under statutes are Guardianship of Infant Ordinance 1958, which applies to all native infants, Land Code 1958, which governs native customary land tenure, and this code recognizes native customary rights to land. The native may hold land under 3 types of areas such as mixed zone land, native area land, and also interior area land. We also have native customary land, which means land with no documentary title but recognized by common law as a land where native have rights to live as their ancestors had done for generations, which is land being cleared for cultivation, fishing, hunting, and gathering forest produce. Native customary rights are also covered under Section 5 of the Land Code. Section 5, Subsection 2 of the Land Code provides that native customary rights may be created by several methods such as clearing jungle, planting of fruit trees, cultivation, use land for burial ground or for rights of way. Whereas Section 6 provides that minister may declare any state land to be native communal reserve. One case which will help on native customary land is the case of Keteng and Tua, where the case relates to native customary rights to land, and the court held that a person can own land if there is land office title. Without the title, the land is a state land. Section 5 also provided that the native customary rights may be lost if the land is not used or abandoned. In the case of Nyalong and Superintendent of Land and Surveys, the court held that no use of land for 20 years was regarded as an abandonment. In the case of Injing and Tuah, the court held that immigration to another district was an abandonment of his cultivated land. And another case that can be referred to in illustrating Section 5 of the Land Code is also the case of no anak nyawai and Borneo pork plantation, which has been discussed before. We also have customs which are recognized under judicial decisions. It relates to cases of family law and property, jurisdiction and choice of law, and etc. The nature of customary law is developed and reflected through the decision of courts. The example that I have here is the case of Tuai Rumah Sandah Anak Tabau and Director of Forest and State Government of Sarawak, where in 2019, the Federal Court dismissed an application by a group of Sarawakian to review a 2016 decision over native customary land rights. The implication was that Sarawak native could not claim native territorial domain based on customs because the ruling said that customs have no force of law. Moving on to our last discussion on the recent position of custom in Malaysia. In Malaysia, the term customary law is used interchangeably with the word adat or native law and custom. The question is to what extent customary laws are relevant today. Customary laws are regarded as personal law, applying only to specific race or religion and are generally in decline. They are being increasingly replaced by stated law. For example, the non-Muslim customary law relating to marriage has been replaced by a uniform law known as Law Reform Marriage and Divorce Act 1976. Custom is recognized in statutory provisions such as Article 160 of the Federal Constitution on definition of law which include custom, Sarawak Native Courts Ordinance 1992 where custom is defined as custom or body of custom recognized by law of Sarawak, and also Law Reform Marriage and Divorce Act 1976 which only recognizes customary forms of marriages. It is undeniable that the Law Reform Act has great effect on the non-Muslim customary law, especially in marriage and divorce matters. It provides for the first time a uniform law on the matters, and the provisions were mostly based on English legislation. Thus, the Law Reform Act abolished polygamous marriage among non-Muslims, imposed a system of compulsory registration of marriage, and also provide irretrievable breakdown of marriage as a main ground for divorce. However, the Law Reform Act does not abolish customary form of marriages. Non-Muslims may still marry according to their customary rights on condition that it is solemnized according to Part 3 of the LRA, meaning that the couple would first solemnize the marriage according to the Act and then go through a ceremony according to customary rights or vice versa. So, solemnization of customary marriage under LRA is carried out on two conditions. First, that the person solemnizing must be a religious officer or an assistant registrar, and the couple must submit statutory declarations to the assistant registrar. In practice, marriages are solemnized in a church, a temple or clan association premises as permitted by the customs or religion, and a registrar is appointed within these places to solemnize marriage and issue marriage certificate. The ceremony under customary rights per se is not sufficient to make a marriage valid. It can be concluded that the Law Reform Act does not affect validity of marriage solemnized under any law, religion or custom prior to the effective date, which is 1st March 1982. And it can also be concluded that the Law Reform Act has no retrospective effect. The Law Reform Act does not apply to native of Sabah and Sarawak and aborigines of Peninsular Malaysia unless the aborigines elect to marry under the Act, or in Sabah, the native contracted marriage under Christian Marriage Ordinance, or in Sarawak, the native contracted marriage under the Church and Civil Marriage Ordinance. Here, the Ordinary High Court has the family division to deal with family matters under the Law Reform Act. Therefore, the influence of customary law today, other than native land rights or orang asli and native customary law in Sabah and Sarawak, is decreasing. Under the Malay customs, only adat pepatih remains practiced in Negeri Sembilan and Nanning, and while Chinese and Hindu customary law on marriage and divorce have also been replaced by the Law Reform Act on 1st March 1982. Malaysia had to choose between preserving pluralism or providing a unified body of law, and the Law Reform Act seems to lean towards the latter. Uniformity of law on family matters makes the law more certain and minimizes problems of conflict of law. Pertaining to native customary law, how long it will remain depends on how long the natives can maintain their beliefs, customs, traditions, and also culture against modern lifestyle brought by economic and social development. Thus, that ends our discussion on customary law. Thank you for joining and thank you for your attention.